Hello guys, welcome to this video. In today's video we are going to look at the case of Criminal Injuries Compensation Board ex parte A. So in this case, Lord Slin said that misunderstanding or ignorance of an established and relevant fact is reviewable, but emphasized that this is more than an application of ordinary review principles. So let's look at the case details. So it is important to note that this case handles errors of fact as a ground of judicial review, and also principles of natural justice as a ground of judicial review. The case took place in 1999 and is the case of Criminal Injury Compensation Board ex parte A. So without further ado, let's dive in. Criminal Injuries Compensation Board ex parte A was a 1999 case in the United Kingdom where a decision by the Criminal Injuries Compensation Board not to award compensation was quashed by the House of Lords, as it was deemed to be a breach of rules of natural justice. The case reaffirmed the principle of misunderstanding or ignorance of an established and relevant fact, and further developed the doctrine of error of fact, in that a decision could be quashed on the basis of it having taken into account a factual mistake. The case also dealt with the issue of undue delay, and guiding principles are laid out. Let's look at the case facts. On May 25th, 1991, a woman known as letter A was seriously sexually assaulted by two men during a burglary at her home. In November, 6 months later, she sought compensation through the Criminal Injuries Compensation Board. As application to the Criminal Injuries Compensation Board was refused verbally on 31st August 1993, and subsequently in writing by the end of 1993. 5 days after the burglary, A had been examined by a police doctor who had confirmed that the findings of the examination were consistent with the allegation of burglary. A was told that she did not need to ask for police statements, as they would be produced by the police. When A's claim was heard by Criminal Injuries Compensation Board, the report by the police doctor was not included, which led to the board taking the view that the police witnesses believed that no medical evidence was available to support her claim. So there was also the issue of undue delay, because when A made the application for judicial review, she was considerably out of time, as the application had not been made within the 3-month period from the date the grounds arose. The question of leave or permission had been dealt with by the High Court, even though A's application fell outside the time period provided by Order 53, Rule 4, the rules of the Supreme Court. The order was granted on 14th February 1995 by Canworth and was described as unambiguous by Lord Slin of Hadley, who went on to say that the Court of Appeal did not have jurisdiction to reconsider the question of an extension of time. So Lord Slin cited two provisions as being relevant to the issue of delay. Order 53, Rule 4 of the rules of the Supreme Court pertaining to good reason for an extension of time, and Section 31 of the Supreme Court Act 1981 which dealt with hardship, prejudice, detriment, and justification for a refusal of leave. A 6-point list was set out in order to help elucidate on the effect of the two provisions. One is that when an application for judicial review is made on an ex parte basis, leave can be refused, deferred to a substantive hearing, or granted. 2. If good reason can be shown for the extending period, the court has the power to grant leave. On an ex parte application, it is expected that the demonstration of good reason will be from the position of the applicant. 3. If leave is granted, an application to set it aside may be made, although the Court of Appeal have stressed that this should not be encouraged. 4. Unless set aside, there is no application for leave to apply for judicial review at the substantive hearing, since leave will have already been given. The question of leave will not be reopened at the substantive hearing on the basis that there is no ground for extending time under Order 53, Rule 4. 5. Unless the court set aside the initial grant without a separate application having been made for that to be done, there is no power to refuse to grant leave at the substantive hearing on the basis of hardship or prejudice or detriment to good administration, as the court would have already granted leave. In effect, it would be too late to refuse leave. The court does, however, have jurisdiction under Section 31(6) to refuse grant leave. And finally, the questions that fall under the two provisions, that is, good reason for an extension of time and hardship, prejudice, detriment justifying a refusal of leave, may be determined if the application is adjourned to the substantive hearing. Therefore, we see that the House of Lords overruled the Court of Appeal's reconsideration because the issue of whether it had been demonstrated that there was good reason for an extension of the period had already been concluded at the point of S application for review, and no good reason had been shown for extending the period within the meaning of Order 53, Part 4(1). So the judgment here is that the Lords unanimously allowed the appeal, accepting that there was jurisdiction to quash the board's decision on the ground of taking into account a mistaken fact leading to a breach of rules of natural justice, which in turn amounted to unfairness. The Lords preferred to base their decision to quash on the ground of unfairness and left the question of review as an error of fact, an area of law in a state of flux to be considered later in time. So this is a very, very key case in especially understanding principles of natural justice and error of fact. As Lord Sain said, that misunderstanding or ignorance of an established and relevant fact is reviewable, but emphasize that this is more than an application of ordinary review principles. Thank you for watching this video. Like, share, and subscribe.